Closed captioning for Justice and Law Weekly is provided in part by the Clifford Law Offices in support of quality public television for the Chicago area.
I'm Aurora Bella Austriaco, President of the Chicago Bar Association, and welcome to another edition of the Chicago Bar Association's Justice and Law Weekly. Most judges in Illinois are elected on Election Day. Citizens across Illinois vote for new judges and to retain existing judges. Most people know little or nothing about these candidates and have no idea where to find information about their qualifications. Judges make serious decisions affecting the lives of hundreds of people each day. It is important for voters to take the time to learn about judicial candidates. Here to tell us how we can elect and retain the most capable judges is Tom Bolke. Mr. Bolke is a partner with the law firm of Butel, Hurst Bolke, LLC. He concentrates his practice in serious personal injury and wrongful death litigation. He is also the chair of the Chicago Bar Association Judicial Evaluation Committee. Welcome, Tom.
Good morning.
And thank you so much for coming here and joining us today.
Absolutely.
Tom, the judiciary is our third branch of government, and I think we need to emphasize why it's important that we elect highly qualified judges. Can you elaborate on that one?
Sure. Well, the judges, for most of the citizens who are going in to cast their votes, the judges are the candidates or the political figures that they're going to be exposed to most. So whenever you have a traffic ticket, or if you're going through a divorce, or anything that would bring you into the court system and before these judges, the judges' rulings or their decisions are going to have a great impact on our lives. So I think it's very important for the citizens, before they go vote for the judges, that they make an informed vote. And one of the ways that they can make an informed vote is by checking out some of the results that we've had from our investigation, the process that we go through in order to select judicial candidates. And so that's what we do at the Judicial Evaluation Committee of the Chicago Bar Association.
Right, and the Judicial Evaluation Committee is it's an independent part of the Chicago Bar Association. It pretty much stands on its own just because of the function that it does, which is to, evaluate the qualifications of judges. What are the factors that you look at, or what's the criteria that you look for in judges?
Sure. What we've done is we've tried to compile a list of objective criteria that we can evaluate judges. So we take politics out of it. We don't consider a candidate's political party or political affiliation, and we simply look and try and find out what makes a good judge. So some of the things that we consider in evaluating these judges are, do they have a broad base of legal knowledge? Do they have proper legal ability in the courtroom? In other words, do they know the law and do they fairly apply the law? Are they diligent? Do they have perfect integrity? Because that's something we certainly insist on from our judges, to have integrity. Do they show up on time? Do they make their rulings on time? Do they start their call on time? And then we also look at their experience as a lawyer or as a judge. And we try and, as I said, objectively put all these criteria together in selecting qualified candidates.
But within also that qualification that you have, there's a two-step process, which is you have someone who does the investigation, and then you have someone who does the hearing of the judge or the candidate who's running for a judge. So the investigation process, I served as an investigator, and I know it's a very, very rigorous process. Can you explain what?
Sure, the two-step process. So the first step is an application has to be filled out by the candidate, whether that's a judge or an existing judge or a lawyer who is going to be running for judge. On that application, it's very thorough. They have to list all their experience, they have to list their education, they have to answer many questions. One of the things that they also have to do is they have to list, if they're a lawyer, they have to list other lawyers that they would regularly come up against in the courtroom. If they're a judge, they have to list lawyers who would regularly appear in front of them. And so we will have, sometimes we have 30, 40, 50, 60 names that, the candidate had to list on their application. We then not only thoroughly go through the application, but then we assign investigators to call all of these references. And there is a chance that they can put personal references, so it'll be family members or friends. But they also have to list judges that they would regularly appear in front of. And as I said, they have to list other lawyers that they would regularly interact with. So if you're a prosecutor in the criminal law section, you're going to list public defenders. Mm-hmm. In the civil law, if you're a plaintiff's attorneys, you would list defense attorneys. And then we go through and we call each and every one of these references, and we ask them their opinions of the candidate's qualifications. And we go through that same criteria which I mentioned earlier. We ask them about legal knowledge, ability, diligence, punctuality, and most importantly, integrity. And then we usually assign 2 investigators because the amount and the volume of work. And then we take that information and we will put it in a report. We'll summarize it in a report. We talk about, we summarize the application itself, and then we summarize the comments that have come in from all those references we talked to. So that would be the first step of the process. The second step is to actually bring the candidate in. And we have a hearing before our hearing panel in which we will ask the candidate certain questions. If there was deficiencies found through our interview process, we'll ask the candidate about those deficiencies and see how they respond. If there is a problem area, we'll ask them to acknowledge that or explain that. And then after they've had a chance to answer our questions, then we take the information from the investigative report we have, we take the information from the hearing that we've just gathered, and we put that together and we vote on the candidate. We will vote either that candidate is qualified or not recommended, or sometimes there may be a highly qualified rating.
Great, great. Now, let's take the election that we just had. How many judges were on the retention ballot?
There was
it 60
60 judges on the retention ballot.
Okay.
So we would have reviewed each one of those candidates. We would have had them go through that same process I just explained. We would have had them come in and do an interview. And then the hearing members would have voted on each of them. So out of the 60 candidates who were up for retention, so these are judges who are already who have already been elected, and now they're being asked whether they are to be retained, we will then post our findings. And our findings for the 60 was that we found that 7 of them should not be recommended. 3 of those candidates were because they did not submit their application or their credentials to us. Mm-hmm. So our rules for the Judicial Evaluation Committee that is if some candidate refuses to submit their credentials to us, we're very suspicious of that, and so we give them an automatic finding of not recommended. And then there were 4 others who went through the process, and we just determined that they were not qualified candidates.
Right, right. Now, how long or how old has the Judicial Evaluation Committee been around? I'd say at least 50 years, right?
A long time before I have.
Yeah,
And I think over the years, I know over the years, they have taken the process and they have refined it. I mean, their overriding goal is to make sure that the process is objective. Right. We don't want people accusing us of not being fair, and that's what we want to make fair and apply the same criteria to all the candidates in the same way. And I think over the years our system has evolved, and I think we have a very fair process now.
Right, right, and I completely agree with you. The people doing the investigations are different than the people who are actually doing the hearing. I just wanted to make sure that that's...
So we have, overall in the Judicial Evaluation Committee, we have roughly 200 members. So these are 200 lawyers who are members of the Chicago Bar Association who dedicate their time and end up, over the course of a year, we probably spend thousands of hours. If you would combine all the hours that the investigators put in on the reports and combine that with the hours that the hearing officers put in the hearings, and that ends up to be thousands of hours. So of those 200 members, a large majority of them would be investigators. So these would be the lawyers who we would assign to a candidate who have to go through that application I described earlier. They then have to make those phone calls that we were talking about to all those references, and then they have to put all that, summarize that all together in a report, which they type up. And then they send to the hearing committee. And the hearing officers are the one then who take that report, conduct the hearing of the candidate, and they're the ones who then vote. But we do have the two, excuse me, we do have the two investigators who were assigned to the candidate. They will participate in the hearing process because we want, since they were the one who made the phone calls, they would have the firsthand knowledge. We want them to be there, and they are also to vote on the candidate.
Right, right. You've mentioned, you know, you spend, the investigator and the hearing officer cumulatively spend like thousands of hours.
Yes.
Are they compensated for the work that they do?
No, this is strictly volunteer work. We think it's really critical information that gets out to the electorate, because not only should the citizens who are voting want good qualified judges, but the lawyers really want good qualified judges too. So it's in our own best interest that we have the best judges on the bench, and so these lawyers are willing to put in all of those hours. They're not compensated at all for that purpose.
Right, right. Yeah, that's a lot of billable hours. My gosh, that they're really doing pro bono.
It is.
So it's actually very, very good. The findings that you have, how are they published? How do we disseminate it? I know the Chicago Bar Association puts it on the website after the results have come out, but what other ways are information on the findings disseminated to the public?
Well, that's, I think, the real challenge that we have each year is really getting all that information, our findings, all that work that we've done to come up with those findings out to the public. And each year we're getting better and better at doing that, I think. Probably the best way for citizens is to go right to the Chicago Bar Association. It is chicago.bar.org.
Chicagobar.org, right.
And if you, there is a tab that you can click on that will take you right to the results from the Judicial Evaluation Committee. And it allows you to print up a, excuse me, it allows you to print up a guide, a pocket guide, that will break down each candidate that has been retained, or if there's, in some cases, there's countywide elections. We also make recommendations on countywide elections. So there's a pocket guide that allows, you can print up, and it's, I think, 2 pages, and you can put it in your pocket, fold it up, put it in your pocket, and take it right into the voting booth with you. And because it's, I mean, there are a lot of names that we, the citizens, those who are voting, are faced in making decisions. It's not only the political candidates, but when you put in all the judges, there are a lot of names. So I think it's something that we've tried to do. We've made it small. We've made it where you can put it in your pocket and take it in, but it'll list all of our findings right there, and I think that's the best way. We have also been trying to advertise. The Chicago Bar Association, for example, this year took an ad out on Comcast, on the Comcast homepage, in which it would link anyone who was interested in it. It would link the findings. It would link to the Chicago Bar site where you could download or print up those findings. So, as I said, each year I think we're getting better at it, but that's really the challenge, is to, excuse me, is to get word out to the public, because the public doesn't know.
Right.
And I also know that the Chicago Bar Association has all of its members make an effort to send out emails or to get these guys out to family, friends, other people that they work with.
Right, right, right. Now, the findings, you talked about the pocket guide and then the voter's guide. Do newspapers pick up the findings of the Judicial Evaluation Committee, as much as we would like for them to all pick it up, right?
I mean, I know that the Chicago Tribune has done a great job in publishing our findings this year, and that's certainly a great help. But you know, I think that then we've talked about this recently after the results from the last election. But I think we really need more of sort of a grassroots effort to hand these things out to people who are walking into the polls, or we need some effort, I think, to really actually get these guides right into the hands of the public. So I think we're going to be working on improving that for the next time.
Right. So we talked about, you know, the public trying to help out in terms of the dissemination of information. Any thoughts on that one? Maybe going to the community leaders of the various minority groups or the various communities that we have?
Yeah, I think there's a couple of things that we could do, and we've tried this in the past, and I think we're going to be trying it again. There are a number of different associations, not only the Chicago Bar Association that will evaluate candidates, but there's the Illinois State Bar Association, and then there's the Cook County Bar Associations, and a number of Alliance Bar Associations. Right. And they all have findings, excuse me, on candidates, and they publish those findings. I think what we have tried in the past, and we will try again in the future, is for the candidates that we can agree on who should not be retained, who we are all agreeing should not be recommended, we need to combine our efforts in that area to get the word out. I think also there is, the politicians could help us. For example, there's an alderman this year who personally emailed out our guide to all of the voters in the alderman's district, and we know from the results that the voters paid attention. So of all of the candidates that we found should not be retained or should not be were not recommended, for this particular alderman's district, the voters followed that. Now, of course, that's only one district, and all of the districts, of course, are combined. Not only the suburban, but the city are combined for the final vote numbers. But in this is sort of an experiment, I think, that was done, and it was really done successfully. And I think that's something that we can work on in the future to get aldermen and other politicians involved in helping to get the word out. Right.
Now, you mentioned that the Alliance of Bar Associations, Chicago Bar, ISBA, they all found the same number of people that CBA found not qualified to be the same for all those. So that actually it goes to the very fact that every organization doing the judicial evaluation had really put in the time and have gone through the same criteria in terms of their evaluation.
I think each one has maybe slightly different criteria. We don't all follow the exact same path, but I think in the end we're all interested in getting the best, the most qualified candidates on the bench. So our goals are certainly all the same. Our process may be a little different.
Right.
And there were some candidates that universally were found unacceptable, and then there were some other candidates that we would recommend or not recommend, and maybe we had some disagreements with some of the bar associations. But yes, there was a core group of candidates that everyone found not recommended, and that's, you know, obviously we really want to try and prevent those judges from being retained.
Right. Now, we're talking about judges. Is it the same process that you go through when you're dealing with the appellate court judges and, you know, Supreme Court justices when they're running for re-election?
We evaluate those judges also. We go through the same process that I just described, and it doesn't matter whether you're sitting in the circuit court, you're in the appellate court, or you're in the Supreme Court. You have to fill out that application. You have to list your references. They all have to be called. You have to come in for an interview. So it really is the same process. It may be a little more thorough on the appellate court and certainly in the Supreme Court, but ultimately it's the same process.
Right. And then when you say it's a little bit more because they've been sitting on the bench and it's a higher office.
Yes.
That would require definitely a lot more investigation.
And they've been lawyers or judges longer.
Right.
So there's just more references to call and more
Right.
information to go through.
Right. Now, have you had a situation where someone found qualified, but they want to have a highly qualified, or someone not recommended? Is there a process where they can file an appeal?
Yes, there is. We, you know, in our efforts to make this as fair as possible to all the candidates, like any process, we have an appellate or appeal process. So if there is a candidate that is not happy with our findings, excuse me, they can submit an application or a request and explain why they think that we got it wrong. Mm-hmm. And then there is a separate appellate review committee that will consider that application. And they will usually call the chair of the hearing to find out what happened in the hearing. And then they will conduct the hearing. And they will decide if there were any circumstances that would dictate having a rehearing of that candidate, or if everything seemed fair and this is just a candidate who's not happy with the result. And so there are times that they confirm our finding and there's no need for a second hearing, and then there are a few times that they found something in the process that they didn't like, and they'll order essentially a rehearing, and we'll have that candidate come back in for a second hearing. We'll have different panel members, because you certainly don't want the same members before. We'll have different hearing panel members, and we'll give that person a second shot, a second chance. And the people who are voting in the rehearing do not know the results of the first hearing. So it's as if it was just the whole process is being done over again. Again, we want to give that candidate every opportunity to state their case and to make sure that the process is fair.
Right. Now, you mentioned that during the rehearing, if it's sent from the appellate down for a rehearing, it's a completely different group of people doing the rehearing.
Yes.
Same token, from the actual hearing to the appellate is a completely different set of people also.
Correct. It's a different section. I served on the appellate committee last year, so it's a smaller group. We have usually 3, 4, or 5 people at those hearings, but we spend a lot of time on each appeal that is brought before us. And as I said, we will call in, or we'll conference call in the hearing officer who chaired that hearing to make sure that we understand exactly what happened during the hearing. And then we have a vote, but it is a separate set of lawyers. It's a separate committee. It has no connection to the Judicial Evaluation Committee. So we like to think of that as being another independent branch.
Right. I remember when I was an investigator, Tom, that whenever I would call, I would always make sure that I tell whoever I'm talking to, whether it's an adversarial reference from that candidate, that everything is confidential. Whatever you say here, you will not be identified, but whatever you say will actually be on the report. And I think that process has worked well, so that you get the real deal, the real story about the candidate.
Yes. Well, yes, I think it's critical if you want these references who have been listed to really tell you what they think of the candidate. They're only going to do that if they know that what they say is going to go only into that report, but not get back to the candidate. I don't think that people would be willing to give up the information that they have, maybe good, maybe bad, but they're not going to be willing to be completely honest and forthright with you if they have any sense that it would ever get back to the person they're talking about. So we go through great lengths to make sure that that information is kept confidential. Only the investigators, the 2 investigators, will know about it. It'll be in the report. And then all the hearing officers, of course, who are conducting the hearing, who have access to that report, would know about that. But they're all sworn to secrecy, essentially, and confidentiality. And so we take that very seriously, because we don't think that we'll have a very fair process, and we don't think that we'd get the information we need unless we assure that confidentiality is throughout the process.
Right. So you have the check and balance, you have the confidentiality. what other mechanisms do you have to ensure that, the process is really fair?
Well, I mean, I think it's just the thoroughness of it. I just think that we have the investigators who do their work, we have the hearing officers who do their work, and they're separate and apart from each other. We talk to all of these sources. As I said earlier, we not only talk to lawyers who someone might be opposed to, but we'll also talk to friends, we'll talk to family members, we'll talk to co-workers, we'll talk to the judges that they work with or appear in front of. And we weigh equally all that information. So I think it's just the thoroughness of the process that makes it fair. The confidentiality, I think it's the fact that the criteria that we use doesn't vary from candidate to candidate. Right. We don't care how they're going to vote on any particular issue. We only want to make sure that they know what the law is on that issue and they fairly apply the law on that issue. We want to know that they can run a courtroom and they can run it efficiently and fairly. I mean, these are the things that we insist on the candidates have before we'll find them qualified. And I think also our appeal process also makes it very fair.
I know we're running out of time. If you want to make a call on more volunteers for the JEC.
We could always use more volunteers. Any lawyer who is a member of the Chicago Bar Association who wants to get involved in this process, you meet some great people, you work with some great people. I think it's interesting, and I also think it gives you a chance to meet the judges, and these are judges that you're likely to be in front of someday at some time. Right. And it gives you a chance to talk to and meet those judges personally. So I really think it's a great experience, and we could always use volunteers.
Great, great. Thanks so much.
Sure.
Tom Balke, thank you for joining us. Viewers, please remember how important it is to select the most qualified judicial candidates. You can access the Green Guide and the Pocket Guide at www.chicagobar.org. I'm Aurora Balastriaco. Thank you for watching the Chicago Bar Association's Justice and Law Weekly.
Closed captioning for Justice and Law Weekly is provided in part by the Clifford Law Offices in support of quality public television for the Chicago area.